Welcome back. My name is Thomas Lundmark, and you are watching my tutorial on the features of common law and civil law systems. The topic today is the methodology of using precedents. But before we look at today's methodology, I'd like to talk briefly about the history of the doctrine of stare decisis. Stare decisis is a short form for the phrase stare decisis et non quieta movere, which means stand by decisions and do not move them. It's referring to judicial decisions, judges of the common law courts. Initially, that is in the early centuries of the common law, the cases that had been decided were seen as evidence of what the law was. They were an aid to help judges decide later cases. Then in the mid-13th century, Bracton published his The Laws and Customs of England. In it, he systematized all of English law, including cases. This preoccupation, some would say, with cases is also seen in the yearbooks. The yearbooks were compiled by law students who would sit in court and record important judicial decisions. They would record the arguments of counsel and the reasoning of the judge or judges. But these were not the judgments themselves. The judgments themselves didn't become generally available until the late 18th century. In fact, for the development of the present-day doctrine of stare decisis, the most important law reports are the law reports by the Incorporated Council of Law Reporting, which were first published in 1865. The development in the United States is about parallel, although it might have started a little bit earlier. So, accordingly, it was the availability and reliability of these law reports that were crucial in the development of the doctrine of precedent as we know it today. Back to the early view, as I told you, was that the totality of appellate court decisions constituted evidence of the common law. But ever since the beginning of the 19th century, most people in the common law world have now assumed that law can be found in individual appellate court judgments. Now, these rules that will be referring to are announced by the judges, and we find them mostly at the beginning of the cases in the form of headnotes. We refer to them as ratios or rationes or ratios, holdings, or simply as rules of the case. We come now to the modern doctrine of stare decisis. It has both a vertical and a horizontal component. We'll start with the vertical component. Simply stated, this means that the ruling of an appellate court on a question of law, whether it is statute law or judge-made law, makes no difference, will be followed by lower courts in the same hierarchy. By the same hierarchy, I mean that the decisions of the trial court will be appealed to an appellate court, and some of those decisions can be appealed to a Supreme Court. And so it is only the decisions of the Supreme Court that will bind the appellate court in a vertical way, and only the decisions of the Supreme Court and appellate court that will bind the trial courts in that jurisdiction. If you think of California as one jurisdiction, there's the California Supreme Court at the top, the California Court of Appeal, and then there are trial courts called superior courts. And it is only the decisions of the Court of Appeal and of the California Supreme Court that are interesting for purposes of vertical stare decisis, not the decisions of any courts in New York, for example, or England and Wales. Why does the common law world have this doctrine of stare decisis? Usually, three reasons are given for the vertical component. The first is equality. Like cases must be decided alike. Secondly, predictability, especially in tax law, but basically in all areas of law. People want to know what the law is, and we can't have judges deciding it one way one day and another way the other day. Similarly, efficiency is a very important quality. What if every judge were to interpret a statute the way he or she felt at that moment? Then many decisions would have to be appealed, and someone, that is the appellate court or the superior court or Supreme Court, would have to make sure that they're the same in order to restore predictability. So if the trial courts do not follow the decisions of the higher courts, the appellate courts, there'll be a lot of inefficiency. There'll be more work for the appellate court judges and more work for the trial judges when the cases are returned. These then are the three main justifications for the doctrine, the vertical doctrine of stare decisis. How does one find precedents? Well, it's easy. It involves the same mental process as looking for relevant statutes. And the rulings of precedents that are usually found in headnotes are collected in the same books that report on statutes. In fact, many, if not most, precedents involve statutory interpretation. Think of it this way. The legislature or parliament enacts a statute, and it's going to happen that there will be situations which were not contemplated and which do not fall within the explicit words, the explicit text of the statute. The judges then are called on to concretize or particularize the statute by deciding, do these cases fall outside or inside the statute? Once they've decided that, they can go back and look at their decision, which is interpreting the statute. So think of what the judges are doing as sub-legislating, and so that it's partially a political activity, not in the sense of party politics, but in the sense of what politicians do in the legislature when they enact legislation. How does one distinguish precedents? Well, distinguishing is merely the word for the justification for not employing the rule of an arguably applicable precedent. When it's practiced by a lower court, distinguishing is the same process as deciding not to employ an arguably applicable statute. However, when distinguishing is employed by the appellate court which announced the rule in the first place, distinguishing might also involve reducing the rule in the previous case to its fact-based result. This will then restrict the scope of application of the precedent. By the way, this is the same thing that happens through a teleological reduction of a statute. We come now to the horizontal component of the doctrine of stare decisis. Stated succinctly, the ruling of an appellate court on a question of statute law or judge-made law will be followed by that court unless it is overruled. Notice that for the horizontal component of stare decisis, there are 4 jurisprudential justifications. The fourth I've listed here is respect for separation of powers. It works like this. I told you that judges, when faced with deciding cases, have to concretize the statute, have to particularize the statute. In doing so, it's a type of legislative activity. You might want to refer to it as sub-legislative. It's as if the legislature were delegating a task to the judges. Now, judges have to do that when they decide the legal issue the first time, but they don't have to revisit that issue because the legislature can do that. The parliament can do that. So, to the extent that judges decide not to revisit an issue, that is, to stay with a legal issue that they've already decided in the previous precedent, and to the extent that they are considering that particular issue, right, then they are thinking about separation of powers. Would it be better if we left overruling of that decision to the legislature? Kinds of overruling. There are basically three, as identified by Louis Kornhauser at New York University: corrective, renovative, and legislative or political. Let's look at each in order. Corrective overruling is sometimes called per incurium, which means through lack of care. That is when the appellate case that seems to apply a rule has ignored contradictory statute or precedent. But there might also be other mistakes, such as if the court had incomplete or inaccurate information. According to Louis Kornhauser, if you imagine an immortal, omniscient judge, she would correct her mistaken judgments. Therefore, we call that corrective overruling. Renovative overruling is when the previous decision was correct at the time, but there have been changes in the social situation, perceptions of public policy, developments of the law, or in other areas where this immortal judge of Kornhauser, who is also omniscient, would update her outdated rulings. Finally, there are legislative or political overrulings. These are cases in which Kornhauser's immortal judge and omniscient judge would not change her personal fundamental values. In other words, legislative or political overrulings are due to the replacement of the judges, basically through retirement and the appointment of new judges. In a study I did, I compared the overruling practices of the Supreme Court of the United Kingdom, the Supreme Court of the United States, and the German Federal Constitutional Court. I concluded that they all overrule at very low rates. I found that the United States Supreme Court was the most likely of these three courts to overrule. The German Federal Constitutional Court was somewhat less likely to overrule. And the Supreme Court of the United Kingdom was very much less likely to overrule. In other words, they're showing more respect for separation of powers. But of course, another distinguishing feature is that the United States Supreme Court and the German Federal Constitutional Court are constitutional courts. And the constitutions are difficult to change. Talking about civil law jurisdictions like Germany, there the doctrine of stare decisis is not expressly recognized. However, remember that civilian judges work in judicial hierarchies where promotion, advancement, is often dependent upon efficiency. I call this institutional stare decisis. In other words, judges have a personal incentive to follow the decisions of judges superior to them. But notwithstanding that personal incentive, there are also the same justificatory reasons for doctrine of stare decisis in civil law jurisdictions as there are in common law jurisdictions. In addition, in civil law jurisdictions, there are often statutes that direct that inferior judges must follow the decisions of appellate judges. Such statutes are extremely rare in the common law world. In addition, in civil law jurisdictions, one finds statutes that require that panels on appellate courts that have various panels must follow rulings of other panels of the same court. The panel that has already made a decision binds the other panels that are faced with the same legal question later. So in conclusion, the actual practices of the courts in civil law jurisdictions regarding precedents are functionally similar to the practices of courts in common law jurisdictions. If you'd like to pursue this topic further, I suggest that you read carefully the script that I prepared for this lecture and also consult Chapter 9 of my book, Charting the Divide Between Common and Civil Law. Thank you very much.